Would children born out of void marriages be entitled to share in the property of a common ancestor as his successors? The Supreme Court was dealing with this issue where it held that the children born out of a void or voidable marriage shall be considered as legitimate children and be treated as an extended family of the common ancestor for the purpose of deciding a valid share in the property of the common ancestor. It was observed in a case where a man who was a common predecessor in interest had 3 marriages, out of which 2 marriages were declared void. Out of these 3 marriages, he had 5 children. The legitimate son born out of a valid marriage filed a suit for partition before the trial court. The children born out of void marriage were pleaded as defendants before the trial court, and the trial court decreed the suit for partition in favor of the legitimate child. As such, the children from void marriage preferred an appeal before the High Court, and it was dismissed. The Supreme Court noted that the admission of the common ancestor to treat the children born out of a void marriage as his legitimate children would also be considered as an evidence against his legitimate child who is claiming through the common ancestor. And after examining documentary evidence, the court inferred that the common ancestor recognized the children from void marriage as his legitimate heirs. To read about the case in detail, go to our website www.livelaw.in. For legal updates and legal news, follow us on Instagram. You can also subscribe to our YouTube channel.